Stop what you're doing and listen closely, because a unanimous Supreme Court decision just fundamentally rewrote the rules for every single person who carries a firearm in their vehicle. If you have ever been pulled over for something as simple as a broken taillight or going 5 miles over the speed limit, the legal ground beneath your feet just shifted in a massive way. And I'm not talking about a close decision. I'm not talking about a 5-4 split where one justice's retirement could flip everything upside down. I'm talking about every single justice, all 9 of them, standing together and drawing a hard, bright constitutional line that protects you the next time you see those red and blue lights in your rearview mirror. This is breaking news for the 22 million concealed carry permit holders in America and the millions more who live in constitutional carry states. But here's the thing. Most gun owners have no idea this ruling even exists. Most people carrying a firearm in their car right now are still operating under the old rules, and those old rules are dead. So let's fix that right now. To understand why this matters so much, we have to start with a real story. Because this doesn't begin in a grand courtroom with lawyers in expensive suits. It starts the way most constitutional battles start, with one ordinary person whose rights got violated in a very real way. The case is Caniglia v. Strom. It started in Cranston, Rhode Island in August of 2015. A man named Edward Caniglia had an argument with his wife. During the argument, he grabbed an unloaded handgun from the bedroom, placed it on the dining room table, and said something that frightened her. She left the home that night and stayed at a hotel. The next morning, she couldn't reach him by phone. Worried about his well-being, she called police and asked them to do a wellness check. Officers arrived, spoke with Caniglia on the porch, and called an ambulance because they were concerned he might be a danger to himself. Caniglia agreed to be transported to the hospital for a psychiatric evaluation, but according to both him and his wife, he only agreed to go because the officers gave him a specific promise. They told him they would not take his firearms. He took them at their word. He got in that ambulance. He went to the hospital. He was evaluated. He was not admitted as an inpatient. He was discharged the same day. And while he was gone, police entered his home without a warrant and seized both of his legally owned handguns. When Caniglia came home and tried to get his property back, police refused. They held his firearms for months, forcing him to go to court just to reclaim what was legally his. So he sued. He argued that what police did violated his Fourth Amendment right against unreasonable searches and seizures. Officers claimed they were justified under the so-called community caretaking exception, a doctrine that allows police to perform general public safety duties outside of criminal investigations. The lower courts sided with police. The case traveled all the way to Washington, and then the Supreme Court of the United States ruled 9-0 in favor of Edward Caniglia. Every single justice agreed. The search and seizure of his firearms was unconstitutional, full stop. Now, before we dig into exactly what this means for you, we need to talk about the legal foundation underneath all of this, because understanding these principles is the difference between knowing your rights and losing them on the side of a road at 2 a.m. The Fourth Amendment to the United States Constitution protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The key word there is unreasonable. And over the last 2 centuries, courts have carved out specific exceptions to the requirement that police need a warrant before searching you or your property. 2 of the biggest exceptions come up constantly in firearms cases. The first is probable cause, meaning an officer has specific, concrete, articulable facts that lead a reasonable person to believe that a crime has been committed or that evidence of a crime exists in a particular place. We are talking real observable evidence, not a guess, not a feeling, not body language. Real facts they can point to and explain. The second major exception is officer safety. Under a 1968 Supreme Court case called Terry v. Ohio, officers can take limited protective actions if they have a reasonable belief that someone is armed and dangerous. In a vehicle stop, this is sometimes extended to the passenger compartment, but it is supposed to be narrow and temporary, not a blank check to dismantle someone's car. Here is where the problem developed over decades of case law. These exceptions slowly became so broad that they started swallowing the rule itself. Officers began using the presence of a legal firearm to claim automatic exigency, an emergency justifying an immediate search without a warrant. Courts in certain jurisdictions allowed it. Departments trained officers to treat disclosed firearms as a trigger that elevated the entire encounter into a more investigative mode. And law-abiding gun owners found themselves in an impossible position. Exercise your Second Amendment right, and you inadvertently surrender your Fourth Amendment right. That is exactly the catch-22 that this ruling dismantles. The core holding of the Supreme Court's decision can be summarized in one powerful principle. Exercising one constitutional right cannot strip you of another. Justice Clarence Thomas wrote the opinion. He made clear that while police perform important civic functions, that recognition does not give them an open-ended license to perform those functions anywhere and in any manner they choose. The community caretaking exception, the vague idea that police can intrude on your property because they feel it is a safety concern, does not override the Fourth Amendment's warrant requirement. Not in your home, not in your car, not anywhere. What the court established here is what we can call constitutional harmony. Your Second Amendment rights and your Fourth Amendment rights were placed in the Bill of Rights by the same founders for the same reason, to protect individuals from government overreach. These rights are not meant to work against each other, they are meant to work together. If exercising your right to keep and bear arms automatically reduced your protection against unreasonable searches, then the Second Amendment would not really be a right at all. It would be a tax on your privacy, a penalty for choosing to protect yourself. The Supreme Court rejected that logic completely and unanimously. The practical consequence is this. The mere presence of a legal firearm is not probable cause for a search. Your legal gun is a neutral fact. It is not evidence of a crime. It cannot be the sole justification for a warrantless intrusion into your vehicle, your bags, or your home. Officers must now point to specific articulable facts that indicate not just the presence of a weapon, but actual criminal activity or a specific immediate threat. A hunch is not enough. A vague sense of unease is not enough. The existence of a constitutional right being exercised is not enough. Now let's talk about why the vote count matters, because this is not just a legal technicality. In today's environment, the Supreme Court is divided on almost everything. You have seen the 5-4 decisions. You have seen the 6-3 splits. So when all 9 justices, conservatives and liberals, everyone, sign their names to the same opinion that sends a message the legal world cannot ignore. It tells you the reasoning is not close. It tells you the principle is not ambiguous. It tells you there is no reasonable argument on the other side, and it tells you something critically important for the long term. This ruling is not fragile. 5-4 decisions can be reversed when a single justice retires and is replaced. 9-0 decisions carry the weight of the entire court's consensus. That is extraordinarily difficult to undo. This precedent is going to be protecting your rights for a very long time. Think about who was on that court. You had conservative justices who were deeply protective of Second Amendment rights and skeptical of government overreach. You had liberal justices who were deeply concerned about police power and civil liberties. Every single one of them looked at what happened to Edward Caniglia and said the same thing. This was wrong. The government overstepped. His rights were violated. That kind of consensus is rare, and for gun owners who carry legally, it is enormously significant. Now let's bring this down to the ground level, because this is where it gets real for you personally. Imagine you are driving home after a long shift at work. Your firearm is legally secured, your carry permit is current, everything is in order. An officer pulls you over. Maybe it's a dim license plate light. Maybe you rolled through a stop sign, something minor. You pull over, roll down your window, keep your hands visible on the wheel. You are cooperative and respectful. The officer walks up and asks whether you have any weapons in the vehicle. You follow your state's law and inform him that yes, you have a legally owned firearm in the center console. The officer notices you seem a little tense because, honestly, most people get nervous during traffic stops, even when they have done absolutely nothing wrong. He sees a range bag on your back seat. He has a gut feeling something might be off. Can he search your vehicle based on that? Under the constitutional principles this ruling reinforces, the answer is no. Your nervousness is not probable cause. Your range bag is not probable cause. Your legal firearm is not probable cause. What you have demonstrated by disclosing your weapon and presenting your permit is not suspicion. It is compliance. You went through the background check. The state authorized you to carry. You are evidence of lawful conduct, not criminal conduct. The officer needs specific, observable, articulable facts pointing to actual criminal activity. Absent those facts, the Fourth Amendment holds. Here is something that will surprise you. Some police departments were actually training officers to treat a disclosed legal firearm as a factor that elevated the encounter, meaning they were taught that knowing a gun was present gave them broader search authority. Courts are now pushing back hard on exactly that approach. Your legal gun does not elevate the encounter. It does not change the Fourth Amendment standard. Exercising a right does not give the government more power over you. That is what this ruling makes clear. Now, to be honest and complete about this, because the law requires honesty, this ruling does not make police powerless. Officers are still allowed to take reasonable safety measures during a traffic stop. Under Pennsylvania v. Mims, they can ask you to step out of the vehicle for the duration of the stop. If they are aware of a firearm, they can ask you to keep your hands visible or in some circumstances ask to temporarily secure the weapon while the citation is being written. If they see something illegal in plain sight, an unregistered suppressor, a weapon with a removed serial number, drug paraphernalia on the seat, all bets are off. The line the court drew is about the search itself. They can manage the scene for safety. They can take temporary, non-intrusive precautions. What they cannot do is use your legal gun ownership as a springboard to go on a fishing expedition through your glove box, your trunk, your bags, and your personal belongings. Safety measures must be proportional and temporary. They can secure the scene. They cannot ransack your effects. So what actually does and does not constitute probable cause? Let's be very specific, because this is the knowledge that protects you in the moment. Things that can constitute probable cause: the smell of marijuana coming from a vehicle in a state where it remains illegal, visible drug paraphernalia in plain sight, an illegal weapon visible through the window. We are talking an unregistered NFA item or a firearm with a removed serial number, fresh signs of a crime like visible stolen property or open containers of alcohol, or a specific and reliable tip connecting your vehicle to a recent criminal act. Things that do not constitute probable cause: your nervousness during the stop, your hands shaking, the fact that you told an officer you have a legal firearm, the fact that you have a carry permit, the presence of a gun case or range bag visible in your vehicle, and a general gut feeling the officer has about you. The distinction between these two categories is the difference between concrete and vague, specific and general, observable fact and intuition. Now let's talk about what you actually do with this information during a real traffic stop, because knowing the law and knowing how to exercise it without the situation escalating are two different skills. First, know your state's notification laws. This ruling does not override them. If you live in a state with a duty to inform requirement, meaning you must proactively tell an officer you are carrying the moment you are stopped, you must still do that. Failing to do so can give police a legitimate reason to arrest you and search the car. Know your state's specific rule before you ever put the key in the ignition. The most dangerous legal gap is the one you don't know exists. Second, be calm and keep your hands visible. Turn on your interior light if it is dark. Keep your hands at 10 and 2 on the wheel. This does two things simultaneously. It physically shows the officer you are not a threat, and it legally diffuses the officer's safety justification before the officer even has a chance to invoke it. Third, if an officer asks whether they can search your vehicle and you do not want them to, you have the right to say so. Say it clearly and calmly. "Officer, I do not consent to any searches." That is all you need to say. You are not arguing. You are not being confrontational. You are exercising a right the Constitution explicitly gives you. If the officer searches anyway, do not physically resist. Comply under protest. But you have now made your position legally clear, and that matters enormously if the search becomes a courtroom issue later. Because of this ruling, any evidence found during an illegal search based solely on your legal gun ownership will likely be thrown out under the exclusionary rule. Fourth, document everything as soon as the stop is over. Write down the exact time, the officer's name and badge number if you got it, what was said, what the stated reason for the stop was, and the sequence of events. If you have a dash cam running, protect that footage. Did the officer say he was searching because you have a permit or because there's a gun? That statement is the exact evidence your attorney needs to win a suppression hearing and potentially have an entire case dismissed. Fifth, and this is critical, the side of the road is not the courtroom. If your rights are violated in the moment, the place to fight back is not in front of the officer's flashlight. It is in front of a judge. Comply in the moment, document everything, and then contact a civil rights attorney who handles Fourth Amendment cases. With this Supreme Court ruling behind you, you now have stronger constitutional ground than at any point in recent memory. Let's be realistic about one more thing, though, because the gap between what the Supreme Court says and what happens to a person on the side of a road at midnight, that gap is real, and it is important to acknowledge it. Just because 9 justices signed an opinion in Washington does not mean every patrol officer in America was briefed on it the next morning. There is always a lag. Police departments have to update training manuals. Every standard operating procedure that allowed automatic vehicle sweeps based on weapon presence is now unconstitutional, but changing institutional behavior takes time. You might still encounter an officer who tries the old approach. If that happens, remember that you are not arguing with the officer in that moment. You are building a record for a judge. Stay calm. Exercise your rights clearly and respectfully, document everything, and use the legal system to fight back where it actually counts. And the implications of this ruling stretch beyond traffic stops. The principle the court established in Caniglia, that the Fourth Amendment protects you in your home with the highest level of constitutional force, and that legal gun ownership cannot become a basis for government intrusion, applies across contexts. Future cases involving concealed carry permit holders and police searches will be analyzed through this lens. Did the officer have actual probable cause beyond the mere presence of a legal firearm? If not, the Fourth Amendment was violated. We may also see challenges to past convictions where evidence was obtained through searches just justified solely by the discovery of a legal weapon with no other probable cause, civil rights attorneys are already paying attention to these rulings. Police departments that have been systematically using legal gun ownership as a search pretext are now exposed to legal liability. Expect a wave of Section 1983 civil rights claims. Expect meaningful changes in officer training, and expect courts to continue applying and refining these principles at the appellate level because this area of law is moving fast. Here is what you need to walk away knowing today. The Supreme Court ruled, with every single justice in agreement, that your legal right to possess a firearm cannot be used by police as automatic justification for a warrantless search. They need real, specific, articulable probable cause beyond the simple fact that you own a gun. Your Second Amendment rights and your Fourth Amendment rights work together. They reinforce each other. They cannot be weaponized against each other. And you are now part of the small percentage of gun owners who actually understand what this means. Constitutional rights are only as strong as the people who know how to use them. The court has handed you a powerful shield, a unanimous 9-0 legally bulletproof shield. But a shield does not protect you if you leave it on the ground. Know your state's notification laws. Stay calm during stops. Decline consent to searches you are not required to grant. Document every encounter where you believe your rights were tested and fight back in the courtroom with an attorney where you now have more constitutional ground to stand on than ever before. The law is not left or right on this issue. 9 justices from across the ideological spectrum looked at the same Constitution and reached the same conclusion. Law-abiding gun owners are exactly that, law-abiding, and the law at the highest level it can speak is protecting them. Final reminder. Everything covered here is educational information about Supreme Court decisions and constitutional principles. It is not legal advice for your specific situation. Laws vary by jurisdiction and every case is unique. If you believe your rights were violated during a police encounter, contact a licensed attorney in your state immediately. Stay safe, stay legal, and stay informed.